In a world where superstition blurred with law, and where animals were seen not merely as property, but as moral agents, medieval courts summoned not only men and women, but also beasts and insects to face human justice. From solemn hangings to bizarre excommunications, the annals of history record trials so strange they border on the incredible. Today, we journey through 5 of the most infamous animal trials, where pigs, rats, roosters, and insects stood before judges, defended by lawyers, and, at times, sentenced with the full force of medieval law. Prepare yourself for a story of absurdity, tradition, and a view into a mindscape vastly different from our own. Our first case takes us to the town of Falaise, Normandy, in the year 1386. A pig had, according to local accounts, attacked a small child in the streets, mauling the child so badly that he later died from his wounds. In a time when animals were considered moral actors capable of sin, this was no mere incident, it was a crime. The authorities took the matter gravely. The sow was arrested, imprisoned, and tried in a formal court proceeding. She was dressed in a human suit, tunic and breeches, to signify her participation in human affairs. A secular judge presided over the trial, and witnesses were called. According to records, one chronicler noted, "The pig, being of sound mind, was fully culpable of her actions." Legal documents from the time, such as the local court rolls, confirm that the pig was sentenced to death by hanging. An official executioner was paid extra for the peculiar duty, reflecting the unusual nature of the case. The execution was public, a grim spectacle intended to reaffirm communal values of justice. Some versions of the story suggest that the pig's owner was fined for negligence, though accounts vary. Nevertheless, the focus remains squarely on the animal itself as a moral agent responsible for its crimes. The absurdity lies not only in the trial, but in the earnestness with which the entire community, from mayor to magistrate, pursued the case. The law treated the sow as it would a criminal citizen, an early and vivid example of anthropomorphic justice. Next, we journey to Basel, Switzerland in 1474, where an equally bizarre yet deadly serious trial took place. Here, a rooster was accused of laying an egg, an act considered not just unnatural, but heretical and possibly demonic. At the time, popular belief held that rooster eggs could hatch basilisks, mythical creatures said to bring death with a mere glance. Fear of witchcraft and dark forces loomed large over medieval communities, and this rooster's behavior was seen as a dark omen. The bird was arrested and subjected to a formal ecclesiastical trial. Lawyers argued the case with gravity, citing ancient authorities and biblical passages. The prosecution alleged that the Rooster's Act was against the natural order instituted by God, a sign of malevolent supernatural interference. No defense was deemed necessary for the unfortunate bird. The court found the rooster guilty of heresy and witchcraft. Its sentence was death by burning at the stake. Eyewitness accounts describe the scene: a small pyre built outside the city gates, attended by a somber crowd. The rooster, oblivious to its symbolic burden, was immolated in fire meant to purify the community. This case underscores how deep-seated fears of the unnatural and the demonic could extend even to livestock. The line between superstition and law blurred until even a rooster's biology became a matter for the court. From Switzerland, we moved to the rural fields around Bern in 1478, where the accused were not a single creature, but a swarm of locusts. The farmers, desperate after seeing their crops devoured, appealed to the church and the courts for divine and legal intervention. An ecclesiastical court convened, treating the locusts as rational beings capable of obeying a summons. A formal lawyer, often a cleric, was appointed to represent the locusts' interests. He argued that the insects, created by God, had as much right to exist as the crops they consumed. Nevertheless, the prosecution demanded expulsion. After days of testimony, including prayers, biblical citations, and appeals to saints, the court issued a solemn edict. The locusts were excommunicated, cursed, and ordered to depart under threat of divine wrath. According to records from local monasteries, ceremonies were held where clergy processed through fields, chanting exorcisms and sprinkling holy water. The rituals, heavily documented in ecclesiastical annals, served as both legal decree and spiritual warfare. The absurdity here was institutionalized. Entire legal mechanisms pivoted on the belief that insects could respond to moral and legal persuasion. Witnesses claimed that shortly after the excommunication, the locusts mysteriously vanished. Whether coincidence or confirmation bias, the case was deemed a success. In 1508, in the town of Autun in Burgundy, rats were the defendants in another surreal courtroom drama. The rats were charged with crimes against the community, namely the destruction of grain stores and fields. The court appointed a defense lawyer, the brilliant Bartholomew Chassanet, who would later become a noted jurist. Chassanet mounted an ingenious defense. First, he argued that all the rats in the diocese must be summoned individually, a logistical impossibility. When the judge agreed to one public summons, Chassanet argued again, how could the rats safely travel to court when cats, natural predators, threatened their journey? These procedural challenges created endless delays. The court, bound by its own rules, struggled to proceed. No rat ever appeared. Ultimately, the case petered out, an inadvertent triumph of the defense. Chassanet's brilliant use of legal formality over substance stands as a rare example where wit saved the accused, even if they were vermin. The records of this case influenced later law books and even inspired fictionalized accounts centuries later. Our final story unfolds in Saint-Julien, France, in 1587, where vineyard holders sued a swarm of weevils for devastating their grape harvests. By this time, animal trials had become ceremonial, but this case carried real economic weight. Again, a lawyer was appointed for the insects. The defense pointed out that the weevils were fulfilling their natural purpose, ordained by divine providence, and that man's stewardship of the earth included coexisting with all creatures. The prosecution countered that human needs and divine favor demanded intervention. After prolonged proceedings, the court issued a curious ruling. The weevils were ordered to vacate the vineyards. Moreover, in a compromise, the human plaintiffs were required to set aside an untouched plot of land where the weevils could feed without interference. Records from diocesan archives describe this peace agreement as a way to balance human and divine justice, though there is no record indicating whether the weevils honored their side. In these strange tales from the Middle Ages, the human urge to impose order on a chaotic world took extraordinary forms. Animals were not merely beasts, they were subjects of law, faith, and fear. These trials, absurd to modern eyes, reveal the medieval mind's deep entanglement of superstition, religion, and legal ritual. Today, these cases serve not only as curiosities, but as reminders of humanity's long journey from mysticism towards reason, and perhaps as strange reflections of our continuing struggle to balance justice, power, and nature.